Hey everyone, it's Sam Bryant from Bryant Taylor Law. I think today is a very good day. I am supporting the whole team, the Dolphins, Miami Dolphins just had a really good draft. I think this is going to be the beginning of an amazing turnaround. I really hope this video ages well. Today, we are going to talk about how, in my opinion, the force majeure clause is not going to work. Before we get into it, Bryant Taylor Law is a business law firm. We help business owners start businesses, and we also help business partners resolve their partnership disputes. So why do I think that force majeure clauses are not going to work? I think in the age of coronavirus, there's a lot of content out there about how if you have a contract with a force majeure clause, you can potentially use that to get out of your contract. A force majeure clause generally is a contract that allows you to terminate your obligations if a occurrence arises that's beyond your control. And then usually in these force majeure clauses, they'll list out reasons why you'd be excused. So they usually talk about government regulations, acts of God, or like labor disputes, and they'll list out a whole bunch of reasons. Very rarely do these clauses have anything that contemplate epidemics or pandemics. So with the coronavirus, we're in the middle of a pandemic, and yes, it has resulted in government shutdowns, but all in all, businesses can still operate. So if you have a business that maybe you can't use your location, but you can still operate, which is a lot of restaurants are doing right now. That restaurant would not be able to use a force majeure clause to get out of their contracts, which would probably be their leases. I think that would probably be their biggest contracts. So if you're a business owner and you've been affected by the coronavirus, I would really think twice before you decide to just terminate your contracts if you're going to rely on a force majeure clause. Because basically, at the end of the day, whether you succeed on that clause or not is going to depend on a judge. And I think that these provisions are going to be interpreted very strictly by judges. So unless you have a force majeure clause that specifically says that if there's a pandemic, you can terminate your obligations and your business is totally shut down because there's nothing that you could do, there's no way that you can operate without having to open your doors in a physical location and you have a non-essential business, unless you have that situation, I would really think twice, because it's going to be very possible that a judge will say your specific force majeure clause doesn't cover pandemics. And there's not a lot of case law out there where a judge can rely on precedent depending on where you are. So use extreme caution if you're going to use this force majeure clause, because again, it's just not guaranteed. So work with your other party to the contract, try to work out some sort of terms, come to an agreement, get that in writing and signed. I think you'll be a lot better off doing that than just proactively terminating agreements and claiming that the force majeure clause allows you to get out of it. So that's my opinion. I hope you enjoyed it. If you did, please feel free to like and comment, subscribe. We try to do these videos on a regular basis. If there's anything on our channel that you would like for us to talk more about, we'd be more than happy to. And I hope you enjoy.